think we can get started. Welcome, everyone. Thank you for coming. I'm 30 seconds ahead of schedule, which I'm going to say, by show of hands, who's seen my TED Talk? A few. For those who haven't seen it, I copyrighted 417 billion melodies. I did that by brute forcing them, just like you can brute force a password by going AAA, AAB, AAC. I did that with music. So I went do 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 re do 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 mi do do fa until I mathematically exhausted every melody that's ever been and every melody that ever can be mathematically. We've done that for 417 billion melodies, and then I wrote them all to disk. Once written to disk, they're copyrighted. And then I put everything that, all 417 billion melodies into the public domain to be able to help You Stole My Melody lawsuit defendants. That is not at all what I'm going to be talking about today. But if you want to learn more, just search my name and copyright. What I am going to be talking about today is a thing like we are all worried about. There's a thing called generative AI, and it's going to change all of our work. I'm a lawyer. I've been a lawyer since 2002. I worked for federal judges and state court judges. So I worked for a law firm, Robbins Kaplan, who actually represented the place we're being right here. So I did a lot of Best Buy litigation work. I represented victims of Bernie Madoff. I also represented people that were kind of pissed about the 2008 securities, mortgage-backed securities. So I sued JP Morgan. I've been coding since 1985. My mom really likes this photo. So really, it puts me really in the center of a lawyer that has worked at big law, that has also been a judicial clerk, that also is a tech guy. There's not really many of us, but I'm really in the center of that Venn diagram. I then left the practice of law in 2015 to say, here's legal tech that I think could change the world. You should build it and hire me. They were dumb enough to do that. So I worked for a couple of years with 100 programmers and 50 lawyers building this really big thing. I left that cool job to do another cool job where I did cybersecurity. I worked for a company called Strauss Friedberg. The biggest thing I did was that Facebook hired me and my company to investigate Cambridge Analytica. So I spent Monday through Friday for about 57 weeks in a row with Facebook's data scientists and my former FBI, CIA, NSA people that worked with me to figure out how bad guys use Facebook data. I did that for 57 weeks, and then I thought, maybe I want to do something else. So my current job, by the way, I also did a TED Talk. This is the TED Talk there. So my current gig is I have now over 750 million judicial opinions and lawyer file documents that I extract the DNA of the law from those things, and then using large language models, tag them all up, and then be able to feed them back in large language models to be able to kind of moneyball the law. Today I can be able to tell you, if you have a motion to dismiss for breach of contract in the Southern District of New York, you have a 53% chance of winning. What I'm building is to say, if you make these arguments, you can push that up to 75%. So the idea is moneyball for lawyers is what I'm building today. I'm doing that through both symbolic AI and also generative AI. And so when people say, what do you do? What I do is lots of things. I'm part product, I'm part R&D, I'm part sales, customer service, I'm part lawyer, I'm part strategy, cyber. I do all the things. And so I'm right in the middle. You might have heard that there's some bots going around in the news. And it really, what I want you to take away from this is that this is not the end. This is a means to the end. That is, there's AI approaches that bots, generative AI is a tool. And symbolic AI is a tool too, right? These are rule-based solutions. This is the code that everybody puts together. And of course, then there's deep learning, neural nets, also known as generative AI. That's what OpenAI and all the other large language models are. So when you think about symbolic AI, that is explicit representations of things. And then, of course, deep learning is implicit, kind of a bottom-up approach as to what matters in the world. So this symbolic AI versus generative AI is something that we've been arguing about since the 1970s or 1980s. Which is better, symbolic or generative? Symbolic or generative? We keep going back. But I think it's pretty clear these days that generative AI is really taking the lead these days. But really, as a product person, you really have to think, okay, what is the problem that we're solving? And then once you say, okay, what is the solution we want to come to? And only after you decide those two things do you decide, what is the tool that I'm going to use? Do I use symbolic AI or do I use generative AI? And that, of course, is a spectrum, because you can always throw enough people at it. You can mechanical Turk it, right? And then you can use symbolic AI, coding, et cetera. You can use knowledge graphs, like those are used by Facebook and Google and Amazon. If you like this thing, you're probably going to like those things. Those are all symbolic AI. And to know that Socrates is related to Plato, is related to Aristotle. These are all knowledge graphs, symbolic AI. The Stanford parser, symbolic AI. And then you get into BERT and these others, which are generative AI. And so really, the difference between symbolic AI and deep learning AI, it's not either or. It's really a hybrid, because these two things work together. So what is the best tool for the problem is always the question, but let's think about the problem. The best tool for the problem usually is not blockchain, sadly. It's usually not Web 3.0, it's usually not NFTs, because that's not the problem that we're trying to solve, right? Users just want solutions, they don't want the tools. They don't care about the tools, they just want the solutions. And so they care about precision, and they care about recall. If it gets you good precision, gets you good recall, who cares what the tool is? Because it's solved your problem. So did you use blockchain? Probably not, right? Because you probably just use SQL because it's faster, better, cheaper. That is solving my problem in a better way. Do you use ChatGPT? Maybe, but is it the right tool for the problem? And so that's really what I want to come back and think about today. So when you think about any system, there is inputs and there's outputs. Okay, the inputs go in, they run through the tool, and then you have the output. I'm going to use this graphic throughout the presentation. So when you think about what is AI, it's generally whatever I don't know about is AI, right? That's it. Back in the 1980s, VisiCalc, the first spreadsheet was AI, right? But now it's just software. MapQuest was AI until it wasn't. It's just software, right? So AI is a moving, kind of a moving target as we go through time. But really, this is, I think, for today, 2023, is a good way to think about AI and think about where we are today with deep learning and natural language processing. These used to be separate things, right? You used to either be an NLP person or you did an ML person. But that's really going together these days with ML is NLP and vice versa. And so this is thinking about these inputs and outputs. There's a lawsuit called Google Scholar. There was a case that the Authors Guild sued Google Scholar and Google Books. The ingestion point was every book that was ever published. And the output was Google Books. As you can imagine, the authors didn't like this very much. They said, hey, you ingested every copyrighted thing out there. You can't do that, Google. But the Second Circuit, which is out of New York and others, they said, you know what? This is fair use. This is transformative use, because what Google was doing was not reproducing the entire book. Instead, what they were doing is creating an index of these things so that I, as a user, can search through that index to be able to more easily find across the entire corpus of every book that's ever happened, to be able to quickly find what I need. So they said the court said this is a great educational value that is transformative. So the fact that you ingested copyrighted works doesn't matter as much as the output is not the copy of the book. It is merely an index of the book, and maybe Google Books shows 3 or 4 pages verbatim, but that's just de minimis. That's not enough to be able to be copyrightable. So anyway, so that's what the Second Circuit decided in the mid-2010s. Fast forward to today, where instead of every book, it's the net, right? The entire internet and all the code on GitHub and otherwise. And then Microsoft and OpenAI created Codex through GitHub. And now we're in the 9th Circuit, so this is in the West Coast, not the East Coast, like with the previous one. And now the 9th Circuit is going to have to decide, well, first the Northern District of California in San Francisco, where this is venued, is going to have to decide, is this like Google Books? Is this like Google Scholar, where it's transformative use, or is it fair use? And if you think about this, this is a lot, if every book ingested that is copyrighted is transformative fair use by creating an index of it and then creating 3 or 4 pages as output, what about all the code, right? And it really is, if you think about generative AI as it is, large language models as it is it really extracting expressions of the ideas or merely the ideas themselves? This is something we're going to talk about more in a bit. Stability AI is getting sued because they ingested all the images, including Getty images. And so now Getty is suing, saying that, and this is happening in Delaware, Getty is saying, hey, you can't ingest all of these images because these are copyrightable images. And look at the Getty Images logo here. That's showing that you actually stole the thing. For those who know how this large language models and the deep learning works, the reason that the logo is on there is because it's so prevalent. That the model thinks that this is just part of soccer players is this logo, right? So this is not, this isn't the smoking gun that I think Getty Images thinks it is. But really, Delaware courts are going to have to say, is this fair use? Is this transformative? So this gets to the idea of idea versus expression, like I was just talking about in a bit. Ideas under copyright law are uncopyrightable. I can't copyright an idea. The expressions of those ideas, those are copyrightable. And that's this idea-expression dichotomy is something we should think about a lot about. So the idea of a person in a man in a black hat going against a man in a white hat, and the black hat guy puts a damsel in distress on the railroad tracks, and then the white hat saves the damsel in distress, right? That is a trope, that is ideas, that is uncopyrightable. But all the movies that have that, the entirety of the movies are expressions of those ideas. Therefore, those expressions are copyrightable, even if the ideas are not copyrightable. So really, when you think about what the ML is doing with all of these deep neural networks, is it's taking the idea of refrigerator and oven and microwave, and it's taking the idea of kitchens and vanities, and it's taking all those ideas and clustering them together. And then once it ingests those ideas, it jettisons the expressions of the ideas, and merely all that's left is the ideas themselves. So think about taking all of the writings, all of the books, all the images, extracting patterns from those things, and predicting what's the next word, what's the next sentence, what's the next paragraph. And then those next words, next sentence, next paragraph, once you extract the idea, the mathematical model of what is the next word, mathematical model of what's the next paragraph, mathematical model of what's the next pixel next to the images. Once it does that, it jettisons the images. It doesn't need the expressions of the ideas anymore. All it needs is the ideas themselves. What is the next statistically likely pixel, next statistically likely word? So now that my machine has the ideas, those are the ones that are most common are the ones that are most likely to be in the output. That is the common facts that are unoriginal, that are uncopyrightable, are the things that actually make its way out into the world as an output of that, in a new expression of the old ideas, which are uncopyrightable. So now this is what all the courts are going to have to say is, all right, is that new expression of the old ideas, by the way, the old uncopyrightable ideas, are those copyrightable, or that fair use, or is it not fair use? So that's at least my idea until I was reading, Mark Lemley is a professor at Stanford, and I was just at Stanford this last week, 2 weeks ago, and I was talking to Lemley, and he said, yeah, but do you know about the red teaming? And I was like, tell me about the red teaming. Well, it turns out that you can ingest books like Harry Potter, and then a malicious actor can say, you know, here as a prompt, why don't you write the first 5 sentences? Here's the first 5 sentences of a book. By the way, it's Harry Potter. Write me the rest of the book. And then if you don't have guardrails, it'll continue writing the rest of the book. So the idea then, okay, is that fair use? Is that transformative? And if you can do that, do you, with a large language model that's ingested the entirety of every book, do you have every book ever printed in your palm? Because all you have to do is do the first few sentences of that book, and then the statistically likely things that happen after that is the rest of the book. So this is the red teaming exercise that might be a thorn in my side. And for that, you need to have guardrails. And that's ostensibly what GPT has guardrails. They ostensibly say, hey, if you put the first 5 sentences of Harry Potter, maybe you shouldn't actually do the rest of it. And the model will not do that. But what do all models have that? That is, does the LLaMA have that? Does Alpaca have that? Does PaLM have that? So this really goes to the post-processing and how the systems that are, or the companies that are implementing these, or the open source projects that are implementing these with DALL-E 2, that's DOLLY 2. That is an open source version of GPT that gets about GPT 3.5 level expertise, but it's free and open source. And so the idea, does DALL-E 2 have these guardrails to be able to prevent this kind of red teaming or not? So now that we have this, now you might say, okay, is the output copyrightable? You know, if GPT creates something, if DALL-E creates something, if DALL-E 2 creates something, is that output copyrightable? And the US Copyright Office would say, no, it is not copyrightable. This is an image by a guy, I've been calling him Thaler for a long time, but I just did a presentation 2 days ago with the Associate General Counsel of the US Copyright Office. US Copyright Office, the guy said it's actually pronounced Thaler, not Thaler. So if you were pronouncing it Thaler, you're wrong, which I was wrong. It's Thaler. Thaler tried to file this with the US Copyright Office saying, hey, the robot made this, copyright it. And the US Copyright Office said, nope, because machine-created works cannot be copyrightable. We'll only copyright human-created works, which seems like it makes sense, right? Because we don't want bots essentially wiping out with life of the author plus 70 years for a monopoly, So they essentially leaves no room for the rest of humans to be able to make anything, right? So that's really good. And if you think back to my All the Music project, that's kind of the same idea, right? I've made 417 billion melodies. Ostensibly, every melody that's ever can be, that was AI generated. I created the algo along with Noah Rubin, and then I hit a button and it had the output. Should I now have a market? If every time you use one of my melodies, should I be able to sue you? No, obviously not. So machine-created work, uncopyrightable. Seems easy enough. Similarly, Thaler also filed a patent, said, hey, AI created this patent. Go ahead and file it, US Patent and Trademark Office. And the Patent and Trademark Office said, no. AI created patents are not copyrighted or are not patentable. He's appealing both of these to the US Supreme Court. So really the question is, if AI generated, therefore not copyrightable, therefore not patentable. So if GPT generated, not copyrightable, not patentable. If DALL-E, either DALL-E the images or DALL-E 2 the large language model, not copyrightable. So this really gets to the idea of ideas and facts are the coin of the realm these days. As ideas and facts are really valuable, and being able to read speed is also valuable. So this idea expression dichotomy that we've been talking about is most important. Let's think one more about Zara of the Dawn. This is who's heard of Zara of the Dawn? This person filed it with the US Copyright Office, and the US Copyright Office rubber stamped it saying, yes, registered. And then the author of this said, I can't believe they rubber stamped this because it was made by Midjourney, or at least the images were made by Midjourney. I made the words. I made the words as a human. The machine made the images. After she posted that on social media, the US Copyright Office withdrew the registration and said, yeah, just kidding. What you get registered is the only human created, so the words are copyrightable, but the images that the machine created, uncopyrightable. Okay, so if machine created, uncopyrightable. If human made it, created, you get copyrightable in those things. So 2 days ago, when I was on a conference panel with this Associate General Counsel of the US Copyright Office, I said, fine if if you have a comic book that has images and words are separatable. How about music? How about if what I've done, and I've actually done this, I said, make a song in the style of Bob Dylan, and it spits out lyrics. I said, add some chords. It spits out some chords. What if I rearrange the lyrics? What if I add a few words here and there? What if I cut out a couple of words? What if I do these? What part is mine, and what part is the machine's, right? And then if I file that with the US Copyright Office, do I have to have some sort of track changes for the music? Right? What if I say to boomy.com, which is something that I can say, give me an EDM song that's 120 beats per minute, that is in EDM style, and then I add my machine-generated lyrics to it, and then to the MIDI that Boomy outputs, maybe I add a few notes here and there, I add a few bars. Am I going to have a track changes of all the musical changes I had from what the machine had to what the human had? And how am I going to tell that to the Copyright Office? And how can you unbake the cake? Anybody who's created anything knows that making art is messy. And you'd have to essentially have a change log for all that messiness to be able to say what is machine created and what is human created. Anyway, so that's what I said to the US Copyright Office Associate General Counsel, and he's like, I don't know. Right? Because nobody knows, right? I mean, this is the thicket we're in. What is human creativity and what is machine creativity? And how many things were filed with the US Copyright Office up to this point where they've used generative AI to be able to say, write me lyrics, write me songs. So this is something that we're going to continue to have to worry about. This is my friend Michael Bomarito. You might have heard that GPT beat the bar exam. GPT 3.5 in December of this last year got in the bottom 10% of the bar exam. That was in December of last year, 3.5. GPT 4.0 got in the top 10%. That is, it beat 90% of humans in the bar exam. Mike Bomarito, my friend, was the guy, along with some others, who did that. Mike Bomarito is doing a legal tech startup where he's extracting all the things from new registries and the US, the Code of Federal Regulations. And then he said, why don't you go ahead and summarize everything in the Federal Registry as a chill pirate lawyer, right? So you can see the output is things like, Mondays may not be our favorite day, but we've got some fresh intel to kick off the week. Sorry to disrupt your morning tide, but we've got just word that the US Department of Commerce, blah, blah, blah. Sorry to disrupt your morning tide. It's kind of fun. So what it's doing is taking the ideas and the facts from the Federal Register and then transforming it into new expressions of those facts. So what's important? The ideas and facts are important. The expressions, you can just run that through a large language model all day long and get millions of expressions of those ideas and the facts. And again, ideas and facts not copyrightable. Only the expressions of the ideas are copyrightable. So now we have to think, gosh, what is even creativity anymore, right? If we all, nothing we're doing is really protected. Think about, this is the Gettysburg Address. That's kind of a famous thing. It's pretty short. Run it through a large language model and say, give me these things as you're a summarizer. Summarize the text below in a hierarchy of bullets, sub-bullets, and sub-sub-bullets. And the output here is pretty easy to read, right? These are all ideas. They're not expressions of the ideas, right? So these ideas are uncopyrightable. Similarly, and by the way, which one can you read and skim more quickly? It's not poetry, but it's more easily done. So this is my thesis, is that as we go forward, ideas are the coin of the realm. Being able to transfer data from my brain to your brain is really going to be the value that we're going to go through. Because expressions like this in the 1800s, this is Judge Learned Hand, try to grok this judicial opinion. Then try to take this summary, that GPT of that judicial opinion. Which one's easier? Which one are we, as we go forward in 2030 and 2040 and 2050, are we ever going to settle for this ever again? And are we going to want GPT and others to be able to replicate this BS, right? I mean, I'm not going to want to skim. Who has time to skim through this, right? I want to look at this. I want to extract the ideas from the thing and quickly grok what Judge Learned Hand was setting. So ideas and facts, valuable. Expressions of those facts, commodities. They don't matter anymore. So why do we write in the first place? Why do we do anything in the first place? We want to take things from our brains, put them in somebody else's brain. How do we do that? You can speak. I'm speaking to you right now. I'm taking ideas from my brain, and I'm trying to put them in your brain right now. Maybe it's landing, maybe it's not landing. I could also do it by writing, right? I could be able to put this in writing, put my ideas into paper, symbolic representations of my ideas. And that symbolic representation goes into yours. You decode those symbolic representations, and hopefully the idea made its way from my brain to the paper to your brain, right? That's another way to express ideas. What's faster to do? Me writing from whole cloth, or using OpenAI to more quickly push ideas to paper to get into your brain to more quickly go there? This presentation itself, I had to be able to push, I'm pushing ideas this very moment into your brains, and I'm trying to do that quickly through writing. And this makes me think, the medium is the message. Marshall McLuhan, who's heard of Marshall McLuhan, he's in the 1970s, he said the medium is the message. And the idea that he was saying is that books versus telephone versus photography versus radio versus television versus movies, the message is not the output, the medium is the message. And these days, of course, that's transformed to the internet and to mobile devices and to neural nets and to what I'm talking about right now. So as I thought about, okay, what is the medium versus message, I was trying to remember what the media were that Marshall McLuhan was talking about. So I asked GPT. I said, what mediums was he referencing? Television, radio, print, films, etc. The way information is shared is as important as the information itself, because the information itself are just merely ideas and merely facts. The expression is just byproduct. That's detritus. So how do we read in 2023? We read in bullet points. We read in summaries. Who's got time to read the whole New York Times article? Let's just summarize it in GPT. Let's just give me some bullet points that matter. And so really, as I think about ways that I'm building tools for lawyers and for judges, lawyers are just like us, readers in 2023. They got no time to be able to read that whole opinion. They got no time to read that entire counterargument. Judges are also readers like you and me. They got no time for these things. So really, we as tech people, we want to think about, structured thinking is structured data. So the coin of our realm is, hey, give me some JSON. Give me some XML. Give me some structured data that I can do stuff with. So really, the way that we communicate in the 21st century, circa 2023, is maybe structured data as ideas. The expressions of those ideas maybe don't matter nearly as much. It's the ideas themselves. So we've said for years that data is the new oil, right? And if you think about this metaphor, oil turns into raw crude, which is then refined, which is then distilled, which is then made in a pipeline and made into a product and then goes out in the marketplace, right? That's oil. Data is the new oil. So what I'm doing right now is I'm extracting data from the courts, I'm extracting data from the government, I'm extracting data from law firms, and essentially I'm distilling that oil and then I'm refining it using OpenAI to be able to extract all of the tags and everything using large language models and other things. I'm also taking that tag data and then I'm making software out of it. This is, of course, software built by people like you, coders. And of course, that is aided by large language models. How expensive are those these days? Using GitHub and otherwise. GitHub Copilot and otherwise. Okay, now the product, what comes out in the product, you need subject matter experts to be able to then reflect what is actually needed out of that refined oil and not needed. And so these are product people and user experience people. And then you have sales people, reputation people, and relationships people. So what is the cost of getting raw data these days? It's still pretty expensive. To go to all the courts and extract that data is really expensive. To be able to then refine it, to do the raw. But to refine that data using large language models, Thomson Reuters down the way had about 3,000 people in Egan. They had 3,000 people refining the data. How many people do they have right now? How many people do they need right now? I compete with Thomson Reuters. I don't need 3,000 people. I need a large language model that just plows through all billion of my documents to be able to tag these things up. So the cost of refining the oil that is legal data is next to zero. The cost of distilling that tagging it up, I run a nonprofit called Sally. Sally is a knowledge graph of everything that matters in the law. We've collected 13,000 tags that matter. Motion to dismiss, breach of contract, Southern District of New York. These are all tags that we're using a large language model to then tag up all billion of those. How many people are we using? Next to zero. The machine's good doing it. So the distilling is costing next to zero. Now the pipeline, if we, a friend of mine, Mike Bomarito, the guy who beat the bar exam, he said that he has estimated that Copilot can give him 10x to 100x improvement on his coding speed, that he can go 10 times to 100 times faster. So as that happens, as you become 10x to 100x faster, what does that mean for your jobs? Product people become ever more important in this new world order, right? Because really, if all of these costs are going down to close to zero, the idea of the product is ever more important. Subject matter experts are ever more important. And then marketing and being able to do sales is ever more important. So really, the moat of getting the raw data, that's still a moat. And the moat of, getting the right product and getting it to market, that's still a moat. The stuff in the middle, that's maybe more commoditized and will become more so as the tools get better and better. I've tried to put myself in every step of this process to hedge my bets, right? We're all, there's a tidal wave coming, right? And we have to all stay ahead of that tidal wave. And so if you think about what is your value as you and I, we have a lot of careers left, in our years. We want to stay ahead of that tidal wave. So when you think about the spectrum of AI, symbolic AI still has a role in these things. So knowledge graphs, as I talked about, Sally is the nonprofit I mentioned earlier. Amazon has knowledge graphs. Google has knowledge graphs. And if I want to solve a problem, the problem is how do I quickly get up to speed on this case? What's the important filings? What's the important outcomes, et cetera? I do that today. Zero large language models. Because large language models get about 90% precision, but my symbolic gets about 99.6% precision. So the right tool for the job, not large language models, it's symbolic. If I want to find out what's my odds of winning this type of motion for this case type in front of this court, symbolic, man. Symbolic all the way, because I don't need large language models to be able to output this. Symbolic is really the way to go. Show me all the winning motions, like mine, for this case, in this court, maybe before this judge. Symbolic. What experience do I have with this document type? What experience does my law firm have with this document type, in this case type, in this court, before this judge? All that's symbolic learning. We don't need large language models for that. What do other firms do my client hire? And for what kinds of work, and do I have better performance than them? That's all symbolic learning. So really, the right tool for the job is not large language models. For any one of those things, it's just symbolic learning. We have smart coders coding up things. Now let's go to kind of the deep learning side. Let's go to make some good counter arguments and good facts. This is a table of contents. It's not just any table of contents, but it's actually the table of contents for a motion to dismiss. And what case do you ask? Turns out it's the case that the coders, the GitHub coders, are suing OpenAI over ingesting all of the coders' code and saying, hey, the coders are saying, hey, this is all MIT licensed and other Apache and other licenses. You, by ingesting it, actually breached that MIT license. Therefore, we're going to sue you for breach of license agreement, breach of contract. So Microsoft filed a motion to dismiss. This is a table of contents from that motion to dismiss. So I thought it'd be kind of fun. Wouldn't it be fun to have OpenAI argue against Microsoft? And so I said, below is a table of contents from a motion to dismiss in federal court. Please create a bullet-pointed list of counter-arguments. And so Microsoft said, lacks Article 3 standing. Standing is what you need to have to be able to be in court. OpenAI said, they have standing. Oh, that's cute, right? You flipped it. They don't have standing, they have standing. But then I said, okay, for each of the bullet points, why don't you include a sub-bullet for the elements of every claim? What do I need to prove to show lack of standing? And this is what came out. They've suffered an injury in fact. It's traceable to the conduct and the decision is likely to redress. Those are all, if you're any lawyers in the audience, those are the right things, right? Then I said, okay, now for each level 2 sub-bullet, provide a level 3 sub-bullet to potentially relevant facts that the plaintiff coders can say that they satisfied the elements of the claim to be able to get passed. And look at this. They suffered economic harm, they lost revenue, and they incurred costs. Those are all good arguments that if I were representing the coders, I would make all those. Then showed that for this particular claim, that OpenAI's actions were the direct cause of the injuries. Give me examples of how a large language model training text and the author of that training text would cause them to lose money. It's kind of on the nose, right? They ingested it without obtaining permission, and I, as a coder, lost revenue from licensing it to other companies. That's a good argument. OpenAI competed directly with my coder's own writings and causing me as a coder to lose clients and lose revenue. That's a good argument. And it's similar enough to cause confusion in the marketplace. My code looks like your code, so people are just like, well, why would I even use your code because I can use OpenAI's code? That's also a good argument, right? This is what I got paid $800 an hour to do as a lawyer. This took me less than a minute. And I know somebody who has access to 1 billion, literally the B, lawyer file documents that have table of contents just like these. And you can imagine, what if somebody were to create a button to say, create counter arguments and facts, and then it spits out the arguments and counter arguments. How long would this have taken a first-year associate? First-year associates charge like $500 an hour. How much are clients going to put up with charging that $600, $1,000, $2,000, et cetera? So this in the legal profession is saying maybe we're going to go from hourly billing to flat fee billing because the clients aren't going to put up with, I spent 45 seconds, therefore here's 20 cents, right? That's probably not going to happen. And then, but then you can also think about, well, perhaps if I, as an in-house client, say I'm here at Best Buy, I'm an in-house lawyer, I'm thinking about going out to my external counsel and saying, I need some legal advice. Give me an answer to this question. So I ask law firm partner assigns associate. Associate works for a couple of days and then spits back, and that's maybe $5,000 to answer that question. That's option number one. Option number two, in-house counsel, use GPT. Doesn't take 3 days, doesn't cost $5,000. It takes 20 seconds and maybe 1/5 of a cent. If I'm in-house counsel, am I going to choose option one or option two? Even if option one, like I'm 95% certain that that's the right answer, and option two, I'm 85% certain, or maybe 80% certain that it's, the cost-benefit analysis there still makes me go to option two, right? That lawyer is never going to know why this phone stopped ringing. It's just going to stop ringing. So now let's go on to statutes, right? I as a coder, know that I have a professor in law school that was not a coder that said, if you want to understand a statute, say, if this thing happens, then that thing happens. And if-then statements are something that's very familiar to all of us here. So I thought, wouldn't it be fun if you just take a random statute? This is just a random New York statute about falsifying business records. It was in the news, right? But this is the one I said, above is the text of a statute. Summarize it in the form of bullet points. If, and, or, then, else, penalty. And this is the output. If a person commits falsifying business records and intent to defraud includes either intent to commit another crime or intent to aid or conceal, then the person is guilty of falsifying business records. The penalty, Class E felony. Imagine if every statute was not written like on the left, but instead written on the right. That'd be helpful for all of our human brains around here, right? Maybe also helpful for machines to be able to compute the law, and for maybe every statute and every regulation to not be inscrutable things like on the left, but is actually machine readable things and human readable things. This is not that far away. I'm an experienced lawyer, so are you. Argue that Donald Trump violated this statute using the elements above. Well, as an experienced lawyer, I would argue that Donald Trump violated this because he intentionally made a false entry of business records with the intention to commit another crime, like tax fraud or money laundering, or aid and conceal another crime, like insider trading or bribery. This is going to expedite the practice of law. I want to know when copyright expires, because it keeps getting extended. Hey GPT, above the copyright statute, when will Purple Rain by Prince be in the public domain? January 1st, 2087. This math checks out. This is all of this math is correct, because it knows that Prince died in 2016, you had 70 years to the death, and then it knows that it expires at the end of the calendar year, so it pushed it to the next one. It's amazing, right? If option 1, option 2, are you going to call a lawyer to be able to do that? How about What a Wonderful World, right? I didn't even ask, what about What a Wonderful World? It knows that there were 2 co-songwriters on that, and it knows that the copyright law says it goes by the death of the last songwriter, and it gave the right answer. One of my friends sitting in the audience right now said, hey, I need to do a privacy playbook. So you're an in-house lawyer, you represent a company that's a retailer, build a privacy contract playbook. Use US law in California. These are pretty good. Now for each bullet point, flesh out the ideas and give me 3 examples how a retailer in California will implement that bullet point. These are pretty good. A California retailer collects names, addresses, email addresses when you sign up for a loyalty program, gathers purchase history to understand and tailor marketing communications. You can imagine this is not the end. It's a good first step, though. And if you are hiring a lawyer, are you going to pay for them to start from whole cloth? Or are you going to say, hey, use GPT as a starting point, and don't charge me the $600 an hour to be able to get to that starting point? Voir dire is something that I want to pick a jury. I say to GPT, you're a jury consultant. Create voir dire jury questions with these facts. Plaintiff coders happen to be suing a company making a large language model. Just random facts. Have you or any of your close family members ever been a developer? Or have you ever coded AI? Are you familiar with large language models? Explain your understanding. Now create sub-bullets of preferred answers and problematic answers. Here are some good preferred answers. I have no close connections. Bad answers? I worked as a software developer. What are jury consultants going to be doing these days? Here's another question. Do you believe that individuals have exclusive rights to their code? Preferred is yes, because I want them to protect their hard work and innovation. That's if I'm a coder, right? A bad answer is no. I think information should be free, baby. I want to make a motion to dismiss, including claims, elements, and facts. Give me a motion to dismiss in the Southern District of New York. Provide the elements of breach of contract claims under New York law, but trade secret claims under California law, and then make the standard of motion to dismiss under the Southern District of New York. Here's the output. I would have spent probably a day to do this output. I need a cease and desist letter. You're an experienced, I received this cease and desist letter from somebody. Somebody's really pissed because I wish them a happy birthday, okay? You're an experienced lawyer, so am I. Write a response that's pleasant for firm, saying you should chill out, but do that professionally. It's my apologies about the birthday. It was never my intention to harass or disturb you. We should be resolving other things respectfully, in more tempered, chill the fuck out, right? But professionally. I need a decision tree on whether I'm going to bring this breach of contract motion or not. Number 1, is there a valid contract? If yes, keep going. If not, go away, because if there's no contract, there's no breach of contract. Did you try to resolve it through alternative dispute resolution? If yes, keep going. If not, maybe there's something in the contract saying you have to do that. These are decision trees that are human grokkable, also machine grokkable. I got a billing record from my lawyer. I want to make sense of it. You're a summarizer. Break everything into bullet points, into 5 levels of sub-bullets. And wherever there's a code, add a label. This is much more grokkable on the right-hand side. than the left-hand side. I, as a lawyer, need to create a chronology. I, as a lawyer, need to draft a contract. I need to extract things from the deposition. I need to be able to find all the things in a lawsuit. Easy. I'll skip over these things because this isn't a legal audience. You don't care about this as much. But really, the next question then is, do we care about we care about symbolic AI or not? So this is something that we all care about. Knowledge graphs is a thing that is symbolic AI. What my friend Mike Bomarito did is went through the entire US tax code. And what Bomarito did is take that tax code and said to GPT, well, actually, let me show you what they did first, and then I'll ask you how you think they did it. This is the entirety of the US tax code in graphical representation. Here are concepts within the US tax code, and it knows that trustee is related to a thing that's called a tax deduction, which is related to a thing called transfer. So here is the entire US tax code in a knowledge graph. Oh, man. Thank you for that. That's right. No human should have to read the tax code. That is an accurate statement. This is getting into my why I shouldn't be doing things. All right, left, left, left. Yes, like that. Thank you for that. How, oh how? How does window? Yeah, AI should be able to do such things. There we are. All right, so here, if I can grok this. So here is all of the nodes, all the things that matter in the US tax code. And it takes every relationship of things and says the other relationship to other things. The way that they did this, I asked Mike, I said, how the hell did you do this? He said, how do you think I did it? I said, well, maybe bag of words. Maybe you just take all the words and said whatever's the most common words, you put it in. And he goes, I would have thought about that. But what he did is said to GPT-4, which knows RDFS-OWL, it knows SCOS, it knows all of these knowledge graph representations, said, why don't you go through the entire tax code and make all the RDFS SCOS elements and show me the relationships between all those elements. That was his prompt. The output is what you see right there. Amazing, right? So this is a bottom-up representation, knowledge representation of a knowledge graph, just like Google uses, just like Facebook uses, just like any of them use. But this bottom-up was created by the large language model. So now you can imagine, okay, what if you took that bottom-up and combined it with the top-down knowledge graph, like I've created at Sally? I know motion to dismiss, breach of contract, Southern District of New York. I also have a lot of tax terms, but I don't have all of those tax terms that he found. Wouldn't it be cool to be able to connect that knowledge graph on the bottom to my top-down knowledge graph to be able to do even more? Retrieval augmented generation is something that, that you probably have heard a bit about. The idea is that if you ask GPT a question, it's probably going to hallucinate. That's probably what's going to happen. But if you say, take these 20 documents and summarize the common themes amongst those 20 documents, it's really good. There's like next to no hallucination. So that's what's called retrieval augmented generation. That is, if you tag these things up using maybe a knowledge graph that is tagged saying, show me all the motions to dismiss for breach of contract in the Southern District of New York in front of Judge Smith, and it gives you 25 of those motions, you could say, give me the arguments that are statistically most likely to win for Judge Smith in the Southern District of New York for this kind of cause of action. It gets really good, right? That is retrieval augmented generation. And that's really the way the future of the law, in my view, is going to happen. So what's better? Do we want robots deciding things? Do we want humans, or do we want hybrid? Generally, we want a centaur, right? We want centaurs to work. And you want to start with the goal, right? Do I want things to be fast, or do I want them to be accurate, or do I want them to be cheap? And then once you decide that, okay, do I want AI or ML, expert system? Like, you decide which of these centaur-like things that we want to do. And you say, okay, what is the precision, speed, and cost? And you also have to think about efficacy for the cost. That is, you want something to be high efficacy, something to work really well at low cost. So, and you want to also take the true positives and distinguish them from the false negatives, and distinguish those from the false positives and the true negatives. And will the machines get you the best true positives and true negatives, and without doing the false positives, false negatives? Machines are really good at doing this problem. Give me all the cats and separate those from the dogs, right? Machines are really good at that. That's a cat-dog problem. Machines have historically been really bad at this. Show me the Chihuahua versus the muffin, right? This, at least historically, circa 2015, was a centaur problem. That is, the machine would kick it to the human saying, hey, tell me whether it's a Chihuahua or whether it's a dog muffin problem. So really, this is a good metaphor for where we're all living right now in 2023. That is, are we solving cat-dog problems that are easily done by machines? Or are we solving dog muffin problems that are not easily done by machines? Especially for lawyers that say, hey, precision is really important. If you're unprecise, you fail. We're not going to buy your thing. So if you have humans do it, right, humans are really accurate but not really good at the dog muffin problem because they're expensive and they're not fast. But for the dog muffin problem, humans are actually pretty good. So the centaur relationship, to be able to say, okay, let the machine take care of the machine good at things, and then let the humans take care of the human things. And then we think about the efficacy, right? There's the cat-dog problems are really at the top, and then dog muffin problems are also at the top. That is the best of both worlds. The tricky part, though, is that dog muffin was true in 2015, but today ML is really good at distinguishing dogs and muffins. So this is a moving target, right? And so we are getting these to go away, how'd you do it? Maybe you had a human, maybe you had a machine, or maybe you had a centaur. It really doesn't matter how you did it. It doesn't matter which tool you used, whether it's a human tool. Humans can't be tools. I guess there are some human tools, but whether you used a human or whether you used a machine. Really the question is it precise? What's the precision? What's the recall? So does it have AI on it? Maybe it doesn't need AI, right? Maybe you just need to throw some humans in it because precision and recall is king. But as I said earlier, will AI take lawyers' jobs? Well, it depends. Are you doing dog-cat problems, or are you doing dog muffin problems? Because, as I said, this was circa 2015, right? This isn't true anymore. So what is a dog muffin problem is now raised a step. And really, that's something that all of us who work in symbolic language should be thinking about. Each of you works in language. Language being Python, language being English, language being whatever, right? The most important coding language these days is English. And turns out large language models are really good at English. So I'm going to skip over a bunch of these things. We are, Bomarito, the guy I've mentioned a bunch of times, he's a brilliant coder. He had a company. First company he had two founders, him and Dan Katz. They hired 20 coders. They had 24 months to build a thing, and then they sold and exited. Company two, they just started. They didn't hire 20 people. They just used two of them. They used GitHub Copilot. And again, I mentioned that Mike Bomarito thinks that he gets between 10x and 100x productivity. Didn't take him 2 years. Took him 3 months with 0 coders hired. So if we think about what is our future here, we should be thinking about how do I compete with that? That guy didn't need to hire 20 of you. He just did it himself. So there's a tsunami coming. And your job and my job is to stay ahead of that tsunami. Because the line of what is a dog-cat problem versus what is a dog-muffin problem is shifting rapidly. So we need to be ahead of that shift. We need to do what is today a dog-muffin problem until it becomes not a dog-muffin problem anymore. And is going to become the next thing. And then keep going through the value chain until maybe we retire, if we're lucky, right? But then after that, what happens, right? What if the machine exceeds human capabilities? And we don't have to not hire 20 people. We don't have to hire 20 million people. That's what we should be thinking about. How many minutes do I have left? What's the end time? So I'm 3 minutes over. Is that right? All right, good. Thank you very much.